Good evening. I, Dipanshu Agrawal, a student at NUJS and the convener of the NUJS Society for Advancement of Criminal Justice, would take the privilege to welcome you all in the third digital lecture organized by the Society for Advancement of Criminal Justice. With us today, we have Mrs. Geeta Luthra ma'am, a renowned senior advocate in the Supreme Court of India, Vice President of the Indian Council for Arbitration, and a core committee member of the Indian Chamber of Commerce. Mrs. Luthra is well known for cases appearing as a counsel in several landmark cases dealing with the subject matters of criminal law, corporate law, constitutional law, arbitration law, insolvency, bankruptcy law, etc. As an alumni of the University of Cambridge, from which she pursued LLM as well as MPhil degrees, ma'am is also well known for arguing in the controversial cases involving Mr. MJ Akbar and Mr. Tarun Tejpal. Today, ma'am will be speaking on the subject area of Prevention of Money Laundering Act 2002 and the amendments carried out in the year 2019. In these times, where the terms money laundering, financial crimes, economic fugitives have found places in the front pages of newspapers and primetime debates of the TV channels, we, as an academic institution, are duty bound to delve more into that area. Through this lecture, the Society for Advancement of Criminal Justice seeks to promote discourse in the field of criminal law after taking corporate law jurisprudence as well as commercial law jurisprudence into consideration. We are sure ma'am's perspective will definitely help us understanding the laws as well as their jurisprudence in legislation in a much better manner. We are indeed thankful to ma'am for taking time out of her busy schedule and to deliver this lecture. The moderator for today's session is Mrs. Vanita Patnaik, an assistant professor at NUJS who has been with the university since the year 2003. Vanita ma'am is an expert on the subjects of corporate law, economic offences, contractual indemnity laws, prevention of money laundering laws, etc. She was also the first Indian student to study at the Summer Academy at the International Tribunal, the law of seas for uses and protection of the sea, economic, legal, and natural science perspectives. She also had a Leicester scholarship from Max Planck Hamburg University of Dundee, Scotland. Mrs. Patnaik has been contributor to many industrial and economic publications on the range of subjects involving commercial law, arbitration law, etc. Ma'am, we are thankful to you for agreeing to moderate this session. I look forward to an excellent and interactive session. Now, I would like to request Anita ma'am to take over.
Thank you, Dipanshu.
Thank you.
That's
Thank you,
really
everyone.
kind introduction. Geeta, we are really privileged to have you here with us, and this is a topic that is close to both of us. I don't think I can add much to what Dipanshu has said more about you, other than you are one of the few gutsy lawyers who call a spade without mincing words, and that is what has earned me respect, whether you know it or not. It has earned my immense respect, and I'm not a person who easily respects people. So as per our schedule, I was supposed to give a preamble of sorts into today's talk, but I will not. I will stay away from it.
Why don't you
I will stay away from it because of two primary reasons. One, I don't really want to take time away from your session. Two, which is far more important, having seen your slides, I don't think I need to add anything more actually. It's really comprehensive, extensive, and it's really very nice. So even if somebody was not presenting it and if I just read it out, I would still understand the subject, but I would rather much hear it from you. So over to you, Geeta. Looking forward to your session.
Thank you so much. You're very kind. You're very kind. And in fact, I've had the greatest respect for academics and people in academia. My husband is also professor at Cambridge in astrophysics and at Delhi University. Having said that, when I came back to India, I thought that I had to give to society. So I had gone back to campus and tried to join as a part-time professor there, lecturer there, but somehow things were not to be. I was dissuaded by the then professor in charge, and I won't say his name. And so that's what happened. but I love traveling within India and speaking to my younger audiences, because I think if we draw inspiration, it is only from you young people. And I mean that um, we draw inspiration from the fact that you have questions, you will question authority while respecting authority. You will not take anything for granted. And in a world of today, you have that opportunity more and more to be able to question that which at one time could have been unquestionable. Now, in so far as the PMLA is concerned, before I go to the PPT, I just want to say a few words. It's a very interesting act, and it was the intention, as when I read the show the PPT, you'll see the intention was really only to prevent money laundering in terrorist crimes and in drug trafficking offenses, because that's where the big money was. It has now been whittled down to even very small, very unimportant offenses, which according to me was not the purpose of the act. But today, what is the interest and why does the act invoke so much interest is because of the big names that have been household names, that have been business world names, that we uttered with great circumspection and in hushed voices. They have all come under the PMLA net. And some of the examples would be the case of Mr. Vijay Mallya. Some cases would be like Nirav Modi. So you are seeing, and the figures have become phenomenal. So you're talking about in criminal trials, you may be talking about cheating of 200 or 2,000 or 20,000. But when you're talking of figures of 5,000 crores and such figures, the whole world turns topsy-turvy, because these people are employing so many people who are working under them. There is such huge industry and huge empires. So when something like that comes crumbling down, then the economy gets hit. So this is one aspect where I feel we have to see the balance. That is there, are we going overboard, or are we in fact shaking the foundations of our economy suddenly? Should we not have been alert from day one? Should we suddenly become alert after 20 years of slumber and then say, let's knock down this foundation? Should we give people a chance to pay up? Or one fine day we decide, yes, we realize that, look, something wrong's been going on for years. Now, let's cut it at the roots. So I feel, as a pragmatic aspect, without looking at only the law, we have to look at also the economy. We then have to look at one side, we are saying ease of doing business. On the other hand, we are seeing that business after business, tender after tender, international contract after international contract, whether we talk of Tetra trucks, whether we talk about helicopters, whether we talk about submarines, and contracts which have been given, which are long given, suddenly become subject. Was this conscionable? Was this above board? Has money passed? How has the money passed? So it's in this context that it has led many people who were business icons to become questionable in the eyes of the public. And in today's day, with COVID times, because it's relevant to talk about COVID times, some of them have been given bails on account of them being immunocompromised. This has happened with one or two of the directors of ILNFS, which in itself is a story where perhaps government has some role, some government institutions, because when you build projects for some huge projects, say a flyover, say a highway, and then people owe you money, government owes you money, but you're so gung-ho that the business will go on, that you borrow and borrow, thinking that this is a cycle which will go on. But the cycle then collapses suddenly and business goes down. So it's not that I am arguing in order to ameliorate what has happened with some of the business houses. I'm just trying to say there are two viewpoints. And that aspect that somebody may have been genuine, may not have been genuine, will have to be looked in, and whether other institutions have contributed to their failure. Some will be out and out. I'll refer to the Satyam case, I'll refer to other cases and show how some may appear to be outright cases where something unconscionable seems to have been done. Whether it was done at the inception or whether the intention became later is not necessary. We have to look at the law as how it has evolved. So coming to the aspect of COVID times, one of the directors of ILFS has got interim bail because he's immunocompromised. But the Yes Bank person, Rana Kapoor, had also said that he suffered from multiple problems and he is immunocompromised, but he has not got bail. I want to start with the quote. Where justice is denied, where poverty is enforced, where ignorance prevails, and where any one class is made to feel that society is an organized conspiracy to oppress, rob, and degrade them, neither person nor property will be safe. I am quoting from this because I want all of you to see whether, in order to tighten the noose on economic offenders, we are not reducing the principles of rule of law or whether the balance is correct. The other aspect I want you to see, which is connected with rule of law, is the aspect of liberty. Is an under trial considered to be an innocent person until he suffers in the trial and is shown to be guilty? Today in India, a lot of us go by media trials. A lot of us get carried away by Twitter, by social media, and then convict a person even before he is convicted. We hear the figures of thousands of crores, hundreds of crores, and we say such a person doesn't deserve liberty. But let's face it, he's still an under trial. So the question then is, what should be the balance between trying an economic offender and giving him incarceration even before his conviction? Should we keep him in the gallows or should we let him have bail? What are the principles of bail? Principles of bail are, there are the principles, and I won't get into that whole detail of it, but a little bit we need to, because one of the main things about PMLA is the reverse burden of proof, which we'll come to. But what are the principles are that bail, not jail. You must have read that in your criminal law, that Balchand and other judgments. Then the other principle is a person's innocent unless proved guilty. Next, in bails is there, how serious is the offense? And in Gurbakh Singh Sibia, which is the parent judgment which has recently been followed in Sushila, what the courts have said is that however heinous, bail can be given, should be considered, and that's followed in another one or two judgments. But I don't want to regress or digress from PMLA. So, two aspects: not to tamper with evidence, and is there a possibility of tampering? And the other is there a possibility of absconding? Now, the possibility of tampering, mostly in PMLA cases, is very little, because the entire chain of events is basically based on documentary evidence. It's very difficult to hide a money trail which has already happened. And today we are seeing, as when I show you the PPT, that all countries are really cooperating with each other. So once there is this spirit of cooperation internationally, to an extent unknown in law before the last 15-20 years, it was unknown that, every country considered it was sovereign. You made a letter rogatory, you made a request, which is a letter rogatory being a request to the other country. Can you give me this information? Can you give me these bank accounts? And the other country may not reply. They won't reply for 5-10 years. You may have cases like before, you are going, lawyers are going, investigating teams are going, they're going all over the place. They're not getting the material that they want. And people are complacent in the fact that this material is not going to come. No country is going to part with it. Look, we have these foreign accounts. Who's going to disclose? That's the condition on which we keep these accounts. And those countries also know this. So that was the general feeling. Today, that curtain has been raised. That is no longer the case. So, therefore, very little possibility of tampering. No one can almost tamper once a case has gone into steamrolling. So once the case has gone into motion, if evidence is not going to be likely to be tampered with, and you make sure the person can't abscond because you can make several conditions, then the question is, should you grant bail or should you not? So these are some of the important aspects with PMLA. Let me start from the PPT. Would the PPT be put up by the host and I'll keep asking for the next slide, or should I put it on? And I would request my friends to keep the Bear Act with them, because it will help them when they have the Bear Act and they are, I refer to certain sections. So coming to the first slide, I want to tell you that this act has been amended more times than most enactments. So you can't have so many amendments. This enactment came into being, it's a 2002 enactment, which came into force actually in 2005, but you soon saw amendments to it. So many of us will go on in life to become legislators, become judges, become law draftsmen, become lawyers who will analyze the law. One of the important aspects which has always been said for a law, that a law should be made, enacted with so much precision and so much thought and so much discussion that it should be good for another 50 to 100 years. See, ultimately, human minds change, we progress, we change. Earlier, there would have been enactments where something was illegal. Subsequently, minds change. For example, about transgenders. So you have new enactments. But otherwise, law should be something which should be able to stand the test of time. But in India, as far as the Money Laundering Act, Prevention of Money Laundering Act is concerned, we've had such frequent amendments in it, mostly to get away from the arguments made by lawyers who have pleaded for grant of bail, who have pleaded for burden of proof, who have asked for relief under the Act, all various amendments, 2013, 2018, the 2019 Act, are all various amendments which are being sought to be brought in to remove ambiguities which, according to me, were not really ambiguities. They are aspects of the PMLA which the courts have mostly interpreted in favor of the defense or in favor of the accused. An attempt is being made that the noose gets tighter. We'll look at these amendments in a bit, because is the noose getting tighter, or are the courts going by the judgments which they had pronounced just before in 2018? Now, the next part, I want to tell you, next slide, the malaise of money laundering made several members of the global community come together, international organizations, the European Commission, the Gulf Cooperation Council, and they formed what is the Financial Action Task Force, FATF. And this was to combat the menace which I told you about. In the next slide, you'll see, which was about terrorist offenses as well as offenses with regard to drug trafficking. Let's go on. Now, this was established by the G7 summit in Paris in July 1989. One of the laudatory objects has been, and one of the important parts is, as I told you when I was giving the introduction, that this has led to a lot of cooperation among countries, a cooperation hitherto unknown. You may have had Interpol, you may have had various interactions and cooperation in extradition in various countries, but the level of cooperation, the level of letter rogatories, you see every day the Enforcement Directorate, which is the main body which is dealing with PMLA cases, is writing letters rogatory, and the CBI is writing letters rogatory all over the world, and they are getting answers so quickly that something which would take 5 or 10 or 20 years or never come is now coming within weeks, days. So now the next one, the process under PMLA. Let's look at the next slide, process under PMLA. So on the left side is the trial under section 3 read with section 4, and on the right side is the adjudication process under 5, 17, and 8. So one is under the criminal law, the other is the civil law. So what is the difference? A trial is a criminal trial. It happens before a special judge. And an adjudication process is the process by which an attachment order is made. The attachment is of the property of an accused by saying that this property is ill-gotten property. It is from money which is this money is tainted. You bought this property, you made this investment, you purchased these shares. All of these are subject to a provisional attachment. This is done by the director and other authorities of the under the PMLA, and then referred to the adjudicating authority. The provisional attachment is for a period of 180 days, whereas, and there are two levels of adjudication. One, if you look at the next slide, you'll understand this. Just look at that. Yes. So, first is the one which was the criminal part. So let's show you the criminal aspect. PMLA envisages what is called a predicate offense. So this is very interesting because a person who is new to the Prevention of Money Laundering Act may not understand that how are you being tried for the same offense twice. So you are being tried under Prevention of Corruption Act, and then you are being tried by the Enforcement Directorate for using your ill-gotten money, or you're being tried for a terrorist offense or under MACOCA, and yet you are also being tried by the Enforcement Directorate for the money that has been laundered and that has passed various hands. So the first most important aspect is, which the 2019 is trying to do away with, that there need not be a predicate offense. This aspect has still to be looked at in a court of law. According to me, most likely the courts will say a predicate offense is mandatory. So originally, it was for very intense, very heinous, very serious offenses that came under the schedule of predicate offenses and predicate crimes. But over a period of time, the number of offences have been added, and this section has been made far larger in scope. So first is, as you see, one, predicate offence, any serious crime. Then you come to two, placement. So you introduce the criminal proceeds into a stream of commerce. Let's take a hypothetical case. A person has supplied trucks. Those trucks have been got internationally. A commission has been paid for getting this contract. Now payment of those commission is illegal. This aspect is discovered at some point, or the money has been inflated for the price of the trucks so that there could be a kickback. So this money, how does, after all, the money has to go to the person who has been the middleman. How does the middleman or the middleman's middleman or the middleman's middleman's middleman, there'll be a chain of people who would have helped. How does that money get placed? So the placement will be maybe in the Cayman Islands, maybe in some other country, maybe in Switzerland, maybe in Liechtenstein, because some are tax havens. Then it has to find a way to India. So then the question is, how does it enter India? So they will find a way to first layer that money in number 3, which is number 3. You layer the money so that people don't know that the source of the money is the predicate crime. And you layer it so that the initial placement can't be tied to the layering money. And then you show it as legitimate money. You show it, for example, money for pens that you may import in or export or whatever, such that that money then integrates, which is in number 4, into the mainstream. Are you able to see the PPT? Is it clear enough, or is it too small? I'm presuming it's clear enough, and I'll go on. Now, the flow of events is that there's an investigation by the Enforcement Directorate, and this investigation normally follows a tip-off from either a financial institution, which are under a duty to inform, or from the police, or from the CBI, or from some other department. You get a tip-off that this money has been laundered and has entered the mainstream. So one is a main FIR oblique case, and the other is a complaint, what is an ECIR, the Enforcement Directorate registers under the ED, by the ED. And once, so the FIUs under this FATF, some of the duties are that the FIUs have a duty to inform. CBI has a duty to inform. Now, normally government bodies should cooperate with each other, but sometimes because they are independent investigating agencies, their investigation will go on parallelly. Sometimes they may even contradict each other. Sometimes their findings will be contradictory and different from each other. Ideally, they should not be. Ideally, there should be complete cooperation. Now, the cases come to the special court, both based on an FIR or a CBI case, an RC as it's called, or ECIR and a complaint from the Enforcement Directorate, it goes to a special court. Now, these are two separate cases. So arguments were made that these are not two separate cases, they should be tried together. But in fact, this is one of the amendments that sought to be done, that they should not be tried together. But in fact, the courts have already said that they need not be tried together. So you will see on my left side the fact that there can be a conviction for money laundering, there will be a confiscation of tainted property, and on the right side, my right, you will see adjudicating authority and confirmation of the provisional attachment. So first, I'll tell you a little more about the FIUs on the next slide, and then I will come back to the aspect with regard to the civil attachment. So effective provisions for attachment and confiscation of proceeds of crime. Special courts have been set up, as I told you. There is to be a disclosure by banks, financial institution, financial intelligence units, intermediaries, and then one aspect which I will come to later, which is statements being admissible. As you will know, statements made to the police, which is the premier investigating agency, are not admissible. Fortunately, unfortunately, and it's a matter which you as young students should look at, is should this aspect be should the statements made to the Enforcement Directorate be admissible or not? For this, you have to see who. It's not judicial officers. You know, a statement made to a judicial officer, a confession or a statement under 164 CrPC is admissible. Why do you make them not admissible to the police? Because the police may be used third degree, the police may force a person, they may pressurize or coerce a person, they may say, okay, you don't make the statement, we'll take your wife or your husband into lockup, we will implicate this one or that one. This fear you don't have with courts, you don't have with magistrates. So this is the reason why police statements made to the police are not admissible, but statements made to the Enforcement Directorate under 50 are admissible, and that is in a lot of similar offenses, and that's an aspect which you need to introspect and see that can there be similar abuse. Who is the Enforcement Directorate? Who are the officers forming an Enforcement Directorate? They are mostly people within the stream of the ED, and there are people on deputation from the police, from customs, from income tax, from other departments. They are not people from the judiciary. Now, what is a proceed of crime? This is important because ultimately the PMLA is all about proceeds of crime. So let's look at the next slide and you will see the important provisions we've come to. Maybe I just shorten this for you. So proceeds of crime under 21U, if you see, they are property which is derived or obtained directly, indirectly from a criminal activity relating to a scheduled offense. As I said, the law is being sought to be changed with regard to this, whether it's held inside the country or outside. Where it's held outside the country, then equivalent value of that property. 3 with 4, as I said, it's the offense of money laundering. 5 is the provisional attachment of property. 8 is within 180 days. 8.3 says confirmation of a provisional attachment order by an authority. This is the civil wing of the PMLA process. So there's the criminal process which goes before special judge, and there's a criminal process, a civil process which goes before the adjudicatory authority. Then 8.6, which will come just now, will come later too, is also pertinent, where after the provisional attachment order, you hear a person. Take an example, just so that you can follow what I'm saying. Take an example where a lady who's an accused has lots of jewelry, and the enforcement directorate says that this jewelry is tainted because it was bought from the proceeds of crime. The lady is able to show from her wealth tax returns, as well as maybe from her photographs at time 20 years ago at some function where she wore them, that this jewelry I had bought 20, 30 years ago. The alleged offense which is committed from the accused, maybe herself, maybe a family member, is being alleged this year or the last year. So how can this be subject to attachment? The court is convinced the court will release the attachment. If the court feels it has to hear the whole matter in detail, it will then decide that under 8.6. And then there is, after that, there is, after adjudicatory authority, there is an appellate authority. So that's part of 5 and 8. Now, section 23, 24, and 45 are other sections which are important. 24 deals with burden of proof, and I'll come more about it later. 45 deals with bail procedure, and on that also I will give a lot more later, because a lot of the law is actually on 24 and 45. Let's go on to the next slide. So I've already given you this. Let's go on further. Can we go to the next slide after this? Yes. Now we come to section 24, about which I just referred. So there are two lots of presumptions. One is 23 and one is 24. I will come a little more to 23 later. That's also a presumption. 24 is the main presumption. And that, if you look at your Bear Act, you'll see in any proceeding relating to proceeds of crime under this act, in the case of a person charged with an offense of money laundering under section 3, the authority or court money laundering or court shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. So the question of reverse burden of proof has been an important issue as part of criminal law. what is the most important presumption? And I'm saying this, I'm repeating myself for the third time, and you may feel I'm being repetitive, is the presumption of innocence. But the moment the burden of proof is changed, then the presumption is reversed. How can you prove a negative? It's very difficult to prove a negative. That is why, for two reasons: one, the presumption of innocence; the other, that you can't prove a negative. It is for the prosecution to normally prove their case. Now, the question which has vexed the courts of law is that enactment after enactment is reversing the burden of proof, is making a presumption against an accused. This gives a very onerous duty. You're sort of groping in the dark and saying, what is the case I should answer? The presumption is already loaded against me. This is very similar to presumptions under many laws. And you have the same issue with NDPS and with other matters. Now, same issue is with regard to 138 proceedings under Negotiable Instruments Act for check bouncing. You've signed a negotiable instrument, presumption is against you. So how do you deal with this presumption? That's an important aspect. And how do you do a reverse burden of proof? So the courts have tried to, and rightly, interpret this, that the presumption is not a non-rebuttable presumption. It's a rebuttable presumption. So all that you have to show is a probable defense. You don't have to show complete innocence. The moment that you show a probable defense, that itself is good enough for then the prosecution to show its case. Now I'll come more to 24 and 23 when I deal with the Satyam case in a bit. We'll just come back to it. Let me go on further to the Indian Evidence Act. So as you can see, the person who makes a claim or asserts a fact is the person on whom the burden of proof is. This, unfortunately, in many economic offences, is being sought to be changed. Next. Maybe I will come to that slide later, but before I go on to section 45, let me speak, just say something which may come later in the slides. Otherwise, I'll just tell you when I talked about Satyam, because I may have not referred to it in the slide. In Satyam case, which everyone has heard about, Ramalinga Raju was one of the main accused, and the case was that his company was doing brilliantly well. He had probably started business at 32, 33 with his brother and a brother-in-law, and the business had shot. It was, they tried to get public subscription in the Bombay Stock Exchange. I think it was manifold times higher, that people subscribed and wanted Satyam shares. The company kept some 25-26% shares and gave most to two international multinationals um, based out of the US. Slowly, they found that the profits that they were showing were not enough, and they expanded it in 1 year. But that became too tempting, and over the years, they kept expanding it such that, and then the owner, Ramalinga Raju, also had there was a company formed by his son and that generation, and they tried to take that over. And somewhere along the way, he then had to confess that there was 5,300 crores worth of excess amounts shown in the accounts. The shares fell, everything became terrible, and the accused were charged, there were attachments, and so on. It was in this context that Section 23 came to be interpreted in 2011 by the Andhra Pradesh High Court, where this aspect, that is this presumption under 24 and 23, though it was dealing only with 23, said, can this presumption be there for criminal cases and civil, or only in criminal cases? So the court said no, it'll be there in civil cases also. And what does 23 say? Just have a quick look at 23, because that is with regard to, if you have a quick look at 23, I'll read it out. Unless you have your act with you, I'll slowly read it. Presumption in interconnected transactions. Where money laundering involves two or more interconnected transactions, and one or more of such transactions is or are proved to be involved in money laundering, then for the purpose of adjudication or confiscation under 8, or for the trial of the money laundering offense, it shall, unless otherwise proved to the satisfaction of the adjudicating authority or the special court, we presume that the remaining transactions form part of such interconnected transaction. So this section came to be interpreted in Ramalinga Raju's case, which is the Satyam case in 2011 in Andhra Pradesh, and the court said that even for attachment orders as well as other orders, this reverse presumption will inure to the disadvantage of the accused. Now, Section 45. Section 45, old wine, new bottle. This, the first thing is, I'll tell you what the old wine was. Then you'll see old wine, new bottle. Because basically, this was the provision dealing with bail. It is very similar to bails under the Scheduled Caste, Scheduled Tribe Act, Section 18, similar to NDPS, similar to Makoka, similar to now the SFIO cases, about which, as I said, I will not be dealing today. So what it says is that no person can be granted bail for any offense under the Act unless the public prosecutor appointed by the government gets a chance to oppose his bail. If the public prosecutor does so, the court has to be convinced that the accused was not guilty of the crime, and additionally, they were not likely to commit any offense while out on bail. Now, interesting. One, all these enactments throw presumption of innocence out of the window. Second, a court may actually say, tell me, how can I be sure he won't commit an offense again? Maybe he's just a first-time offender. How do you know he won't? Something may not happen. Second is, the way the language is termed, it was weakening the effect of section 438, 437, 439 of the CrPC, which deals with powers of bail. So what it's basically saying is, think before grant of bail. Is it in the face of Article 21? Question is this. Here's a heinous man. He's allegedly run away with 5,000 crores from the country. Should he not be behind the bars? So, if I was a common man and I was taken by social media, I would say, he looks guilty. Don't give him bail. Maybe he'll run away like many of the accused have run away. But sorry, that should not be the law. The law seems to envisage, and section 65 of PMLA envisages, that the CrPC, unless contradicted, will be applicable. In any case, Article 21 is there. Article 14 is there. What has this person done which another offender, alleged offender, under trial, and therefore not even an offender, may or may not have done, that man with a 3-year punishment or 7-year punishment will get bail and will have the advantage of the Supreme Court judgment in Arnesh Kumar, a notice. And what has this man done that he whereas in Arnesh Kumar, Supreme Court says any offense which is up to 7 years. Before you arrest, you give notice. And it complies with 41A and those provisions of the CrPC. Section 45 is just completely turning around. Why? Why should there be these twin conditions? Of course, these are tempered in that unless it's a woman or a person of old, infirm person, etc., etc. But that's not the issue. So, Justice Nariman, in Nikesh Tarachand Shah in Union of India, 2018, Volume 11, SCC, page 1, in a beautiful judgment, which I think every person who wants to read about bail and rights under Article 14 and 21 should look at, as well as who is interested in criminal jurisprudence of presumption of innocence and bail to a person who is still in under trial, should look at. And the court struck down these twin conditions. These have been reintroduced from the back door or in another manner by Parliament by the 2019 amendment. And about that, I will say a little later if the time permits. Otherwise, what it's trying to do is nullify the effect of Nikesh Tarachand Shah, which has been a beacon of light in judgments pertaining to special enactments where the rule of bail not jail has been turned on its head. So let's look at the next slide and we'll see if we have more time to deal with the judgments under 45. Now, we are all aware that under the Constitution, the rights of an accused under Article 20 and 22 have been given some protection. Among the protections is the person should not be forced to testify against himself. An accused has a right of silence. But this is coupled with what I just spoke about, the fact that there should not, statements made to a police officer are not admissible, but statements made to ED, an enforcement directorate officer, are admissible under 50. So the way it's been upheld in Dalmia Cement is by saying this, that a person who's summoned under 50 and makes a statement is still not an accused. So I don't know, and this is something we need to see. Of course, he's not an accused, but he may become an accused. He will become an accused. Can you then use that statement against him? The answer clearly is yes, and it's gone on in a catena of judgments, including under Customs Acts, I think under the Act 108. But the question here is, should it be admissible? It is admissible. It's been upheld by the courts. Is there a danger in that? That's what we, as students of law and criminal jurisprudence, have to look at. Now, let's look at the next slide. So, we do know this, that person accused of CBI crimes or FIRs or other crimes, Forest Act, any other act, may also be accused parallelly of offenses of money laundering. And that's very possible. Now, the courts have held that the two will not be heard together. They are different investigative agency. They have different investigating officers, so the two can be heard separately. Now, to that extent, the amendment being sought to be made that they would be heard separately. The other attempt is that it's a standalone offense. There may not be a predicate offense, and yet it can stand alone. Now, one aspect which I wanted to point out when I talk about this is, if you've done enough work on cognizable and non-cognizable cases, is the question whether is it cognizable or not. This is also being sought to be amended, shown by 2019 amendment, because the earlier amendment made it non-cognizable but left the title as cognizable. So the courts then relied on judgments which say it is not the heading or the title which is relevant, it is the substantive section which is relevant, and that is an aspect of interpretation of statutes which is universally recognized. Now, let's look at seizure of property under PMLA and the applicability of the CrPC. So, I've just told you Section 65 CrPC is applicable unless inconsistent, and the courts have held that, particularly in that Nikesh Tarachand, that CrPC is very, very applicable, and bail conditions or bail provisions of CrPC are applicable, and you cannot discriminate against people who are accused of PMLA offenses. While I say that, I want to say one word, that identical provisions under SFIO, about which maybe we can talk at some other time, identical provisions under SFIO are being examined by Supreme Court, which examines this in Rahul Modi and says, we know that the Supreme Court has struck down these twin conditions in PMLA, but we can't say about SFIO, and we'll examine this at a later time. So, the aspect is that Supreme Court has already struck down these provisions under PMLA, but under the Companies Act for the SFIO investigations and bails under that, the court has not struck down these conditions. Am I overstretching my time,
No,
Dipanshu?
ma'am. So we have around 35 to 40 minutes. So we'll take a small Q&A session or 20 25 minutes if time permits. 20-25 minutes Q&A session.
Okay. So what I'll do is, I will, if you want to ask some questions, I'll speak for another 5 minutes, and then they can talk or ask questions. Is that
Sure,
good?
ma'am. Sure, ma'am. Thank you, ma'am.
Yeah. So let me leave most aspects of it and come towards one aspect which was discussed in one of the salient cases which just recently happened, which was Augusta Westland, where one of the grounds for grant of bail was that can ED file supplementary complaints. Thereafter, judgment of Delhi High Court Justice Mukta Gupta has said that supplementary complaints can be filed. But the law basically envisaged that normally you can go on the next slides, I think, come towards filing of supplementary complaints. About 10 slides down, I think. Further, yeah, here. Yes, let's pause here. So the question is, there have been 4 or 5 supplementary complaints being filed. Now you can't file a case against a person and then keep filing supplementary complaints, because unlike when you filed a charge sheet, there is a provision under 173(8) that you can file supplementary charge sheets if court permits and if there are reasonable grounds. But ED has been filing supplementary complaints as if it is giving a 5-course dinner. So it keeps serving these new plates on the menu. That actually should normally not be permitted unless the court has permitted. Justice Mukta Gupta, single judge of Delhi High Court, says supplementary complaint after that bail and after that objection was taken. In another context, the court says supplementary complaints can be filed, but the court hedges it in that it has to be on reasonable grounds and where the special judge has allowed. So this aspect is something which I believe should not lead to further and further, because the moment that you are wanting to do a complaint, then your complaint should be investigated and well founded. Unless some new material which is absolutely unknown and which couldn't have been discovered before you file the complaint. But that's not how the Enforcement Directorate is doing it. The police used to always do it like this. They file supplementary charge sheets, but normally the courts have been very strict in allowing them to file only in special circumstances. Now, the next two slides I may not get into. So, the PMLA versus IBC, this is an interesting case, so I'll talk about it. It's a Delhi High Court judgment in the Axis Bank case, or one of the cases where money was owed to a bank, and a mortgage or guarantee was given to the bank on the loan taken, and then ED came and said, this is tainted money. The court said, insofar as the right of the bank is concerned, which didn't have knowledge, gave the loan bona fide, the right of the bank would have precedence, and not the right of the ED to attach that property. This judgment has been seen as a landmark judgment, and there was this whole tug of war between NCLT and DRT and DRAT and the PMLA and special courts, adjudicating authority and the appellate authority. And to a large extent, this judgment of the Delhi High Court, very well reasoned, has satisfied this, because in a way it talks about third-party claims and their rights, which also deal with the next three slides, in fact. And having said that, I feel I have overshot my time with you and told you about various aspects of the PMLA, in particular section 3(2), which is the definition, 3, 4, 5, 8, which are all adjudicating authorities, and then laws under 2445. Okay, about 45, I wanted to say one line, which I said I'll tell you if there's time. That's gone to various high courts, I think Madras and one other high court, and they all decided on the basis of Nikesh Tarachand, saying that even though there is an amendment, they would have to, since Supreme Court has ruled on it, they will go by what Supreme Court has said and consider the grant of bail without considering these twin conditions. As a result of which, bails under PMLA, mostly after some period of remaining in custody, though there's no reason why anticipatory bail should not be given, is being granted. So these persons have to apply two lots of bail, one from the CBI offense and the other the PMLA offense. The question is, should a person have to keep running from pillar to post, because really it's very similar, and should they be arrested the moment they are released in one, taken into custody in the other, or should it run concurrently if they are under trials, the same way as it does for those who are in trial? But on that, there is much debate. There will be a lot of issues if such a law were to be laid. Thank you, folks. Thank you very much for listening to me so patiently.
Thank you so much, Geeta. You left us wanting more. And with that, I think there are quite a few questions which I would
Okay.
like to take up. The first question that we have is with regard to what you mentioned about the proceeds of crime. The amendment has made some certain changes to the proceeds of crime. Now, proceeds of crime and the distinction between the usage of proceeds of crime. If you could elaborate on that.
So insofar, I let me do it as adequately as I can. So, insofar as the proceeds of crime are concerned, the definitions over the last two amendments have sought to uh, enhance the net or increase the net more and more, in order that the proceeds of crime become in a larger ambit. And basically, what it seems to be saying is, proceeds of crime mean any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value of such property, or where such property is taken or held outside the country, equivalent in value held within country or abroad. So in practice, what has happened is that there were many cases where people were accused, and those assets which were being sought to be attached were assets which were unconnected with the proceeds of crime. But by means of this amendment of 2015, I thought it was, am I right? And partly 2000 or abroad, 2018 also, they've sought to expand it so that they will bring other people in the net. Now, the question, of course, will be, and this will be a matter of interpretation, that can it apply retrospectively, because it should not. The attempt will be to keep all those properties in the net which have got in the net but where they are moved. Adjudicating authority is mostly confirming provisional attachments and the interim attachment orders. But the appellate authority, where it is finding that the property should not be considered proceeds of crime and it's independent acquired property, has been releasing them. The attempt of this definition is to actually bring these in the net. To my mind, the retrospectivity aspect will hit previous cases and will apply. Therefore, it's only future cases that will come under the net. But Vanita, you can add to it if you have a view, please.
Well, my point with in this regard would be with what has happened with the Bhushan Power and Steel. The SFIO moved after the CIRP process was over. The IBC is clear that moratorium applies during the CIRP process. So they waited for the CIRP process to be completed, and they moved after that, seizing the whatever mines they could in Odisha and other places. So Yeah, the usage of proceeds of crime, I feel, can be one very interesting debate. And I believe this to be a law that will be more court settled than legislative made.
Yes.
So, um, so with that, can we move to the next question? I think the students are getting a little bit antsy that they will lose out on your time. So the next question is
No,
from
no, no.
Alikya, and her question is: if would it have a cross-border implication, particularly if it is not an offense in the other jurisdiction?
So this is an issue, actually. Uh, I feel that most um, most offenses will happen, or monies will be transferred to havens where the nature of offenses that are being alleged, and this is an argument which will be made. You see, Vijay Mallya can very well say that this is really a civil case and you're making a cheating case out of it, or a fraud case. There is a very thin line between what is fraud and what may be a civil misdemeanor. There will be cases like that. So the question that can possibly be argued is, this is not a misdemeanor in the UK, because there will be many cases in the UK where people have sunk and the bank's money has been not returned. Why would you put this in fraud? But the because of this FATF and other extradition laws, most countries would take it to be an offense in India and would allow the extradition. So this is as far as the criminality cross border is concerned. You look at extradition. Extradition law is that it should be an offense in both places. So that, for example, if you take our laws like 498A, IPC, etc., these are not offenses in any other country. Therefore, these are not extraditable offenses. Plus, the offense in many countries, your treaty will be that it should be at least offense punishable with more than 2 years or more than 3 years. Then only, so there will be cross border implications. Now, are you also asking for? Yes, you are only asking with regard to criminality. So criminality is seen with your extradition treaties, bilateral and otherwise, with all these countries. That's how it's seen.
There is a linked question a bit further down by Anish Agarwal. He speaks about the Fugitive Economic Offenders Act, and I believe somewhere Alekhya also intended on those lines. So his question is, with this Economic Offenders Act and PMLA, if they're linked or they're sought to be linked or not linked.
So I think what had happened is that when they were not being able to get everyone in the net under the PMLA, and the Fugitive Offenders Act is a much more serious act than, and a much more stronger enactment. That's how it was brought in. I think it was brought in later, if I'm not mistaken, and all these people were brought in for that purpose, actually. Now, if you look at 21RA, that sort of deals with cross-border implications. So it's interesting to look at that. Any conduct by a person at a place outside India which constitutes an offense at that place and which would have constituted an offence specified in Part A, B, or C of the schedule had it been committed in India, and if such person transfers in any manner the proceeds of such conduct or part thereof to India, and then 2, any offence specified in Part A, B, or C of the schedule which has been committed in India, and the proceeds of crime or part thereof have been transferred to a place outside India, or any attempt has been made to transfer the proceeds of crime or part thereof from India to a place outside India. But I think a lot of your answer would come under extradition laws, because that's how you would say it's an offense of cross-border implication. But the question is, would you be, if it's not an offense in that country, then of course you have the extradition laws which won't permit it possibly. But if you're talking of cross-border implications, then according to me, 2RA is the definition which is dealing with what is a cross-border implication. Is that answering your question?
I believe so. So, if I can extend this question a little bit,
Yeah.
the Economic Offenders Act enables seizure of property abroad. PMLA does not.
Yes, yes, that's right. And that is
So
why
that is
it was brought in.
so that is where they intersect, I would say. So moving
Yeah.
to the next question, it's a little bit more interesting question. It says, this is by Atmik Jain. He says that does PMLA fail to protect legitimate third-party transactions, particularly that made to seek legal representation, like US and Taiwan provide safe harbor clause to exclude transaction made to secure such rights? This question itself is not particularly very clear. I believe what he's trying to ask is whether PMLA will enable a genuine transaction, or will it prove to be an inhibitor on that?
So this is very difficult. According to me, the courts are being a little conservative, and they are in, so it's supposed to protect third party transactions, as you would have seen in the PPT. I skipped part of it, but I read out the I explained to you the Axis Bank case, which was third party transaction, which are saved. But having said that, the question is, there it was a bank. So the courts weighed in favor of a bank as compared to an individual. Now it will depend a lot. It is supposed to save third party transactions where they are genuine and the person doesn't know about it. But does it save them will be a matter which the courts will decide. And to my mind, mostly conservatively, unless you can show clear disconnect, a very, very clear disconnect.
Moving to the next question, Divyanshu Mehta. His question is, what relief can one get in case of shoddy investigation? Most of the times one observes that the government servants get away because of shoddy investigations. I don't entirely agree with this statement, but let me hear your answer first.
So it's the little I have seen, and it may surprise most people to say it. I'm just saying from my practical experience, I may be wrong, that the investigation by the police is normally a little better than by some of these premier investigative agency. Because according to me, the police is trained to investigate. One of the aspects that's being sought to be done is to make investigation more scientific, even with the police, so that they also don't get away with shoddy investigation. But I give that Arushi's, that murder case as an example, that you saw such a flip-flop that surely one or the other investigative agency was shoddy. I can't say who. The same agency also had two interpretations. So the fact is, there are actually two views to it. One view may be, should innocent person get implicated because of shoddy investigation, and should you be able to say, for example, in that Priyadarshini Mattu, the court acquitted because it said that the investigation's been so shoddy, the tie-up is not there. But somehow the High Court and other courts felt still a person shouldn't go scot-free. My own finding is that if an investigation is shoddy, however heinous, a person has to go scot-free. So then the question is, and this is a question which we ask ourselves a lot, should you come to what is the European system, where one magistrate supervises an investigation and then another one tries it, rather than having only the police or the prosecution investigate. This much is there, that the police, the CBI, the ED, any investigative agency do only a one-sided investigation. This is not their job. So probably in that Nityanand case, the court has said that they are bound, which anyway they were bound, but the court has said it also, they are bound to put it in their file, even though that is the defense version or the other viewpoint, even though that they don't agree with it. So that's some assurance to a person, which is also perhaps the reason why they are letting complainants have more of a role in the trial. Now, there are bad things about it and there are good things about it. The bad thing about it is that I don't think a complainant should have a role, because it's a state case and people shouldn't be allowed to be vindictive. The good aspect about it is that if there is shoddy investigation, the complainant can assist. So I feel the assistance should not be such that they are allowed to become vituperative or vindictive, and the court should come down heavily, or the investigation should come down heavily if they do that. But they should be allowed to supplant the material which should be taken on record, so that shoddiness of investigation is avoided. And I do feel, although I don't agree with any criminal case being lodged for a government servant doing shoddy investigation, I do feel that a sample example of doing departmental action for shoddy investigation, if it's done even in a small percentage of cases, it will make investigative authorities sit up and be fair. And what I mean is, shoddy is not that you have to convict. Shoddy is when you give the partial truth and you suppress the remaining truth.
Absolutely. So that is where I would have started saying that when there is a conclusion provided to the investigative agencies and they have to start from the conclusion instead of from the evidence. That's where you end up with a shoddy. Else they do a pretty good job. They know what is the fact and they do how to see through it. And then I'll just move to the next question. This is by Dipanshu Agarwal. You have already answered this question, but I'll mention it because it's in the list. So Section 45 of the Act has been controversial with Supreme Court, deeming it to be unconstitutional. However, the changes in the amendment still weren't that huge. So he's asking for a comment on that.
So let's look at what's the change. I think the change is huge in the sense that it's trying to bring back what was taken away. So let's just look at the amendment and then I will tell you. Provided that a person, no, it's not just there. I'm just telling you, I'm reading out that part. 5. Notwithstanding anything contained in the Code of Criminal Procedure, no person accused of an offence under this Act shall be released on bail on his or her. So when they brought in under this Act, the attempt was to bring back or nullify the effect of Nikesh Tarachand. Otherwise, obviously, it's under this act. It can't be under any other act. When Supreme Court has struck it down, it's obviously was part of this act. Wasn't 45 part of this act? Why will we try overreaching the court by this? The other interpretation which was being sought, which is being sought to be brought in by this amendment, is provided that a person who is under the age of 16 or a woman or sick or infirm or is accused either on his own or along with other co-accused of money laundering a sum of less than 1 crore may be released on bail. So what it tried to do was that if it was less than 1 crore, then the rigors of Section 45 won't apply. When the court has said that because of the play of Article 14 and 21, the rigors of 45 won't apply, and that 437, 438, 439, the normal criminal law can't be turned on its head, then by saying this and trying to take out those under 1 crore but include in the net those above 1 crore is really trying to not give effect to what the Supreme Court judgment said. And for that, if I might have those 2 judgments, but otherwise you can look them up. They're very easy to find. This aspect has been looked at by various courts, and I think one was Madras and one was perhaps there were 2 high courts which have held this, that 45 can't be, you can't get rid of 45 by just making an amendment, and judicial discipline makes them bound to go by what has been the interpretation by the Supreme Court. I'll be able to send you that judgment if you're interested, but it's very much available, and I have it somewhere, I'm sure. I'm not finding it just now.
Geeta, I'm sure my students are quite adept at searching it out themselves. Don't worry about it. Don't worry about it.
I'm just not happy with myself for not being able to cite it. But
that's quite fine. That's quite fine. I mean, that's one thing that we are actually fairly proud at NUJs, that we impart good research skills to them. So moving to the next question, it's actually
I'm being prompted. The other was Madhya Pradesh. So
Ah,
One
okay.
was for
Yeah. So Section 72 gives power to the center to set up ministerial committee. Do you think it will benefit in any way having a ministerial committee? I mean, what's the purpose of a committee?
So, so I, my own view is, once I was arguing in court, and I was told by the court, because I was doing it with my usual vigor and uh, overzealous manner, that you're more loyal than the king. So what happens is that government servants are sometimes more loyal than the king. So what happens is it's a case of overdrive and overzest. The only advantage of ministerial committees is this, that they normally have a sense of balance. If you don't, instead of a ministerial committee, you have all the political parties thinking well, then you'll come out with something which is balanced, because you need a balance between um, the chance for business not to feel witch hunted, and at the same time for those who are not genuine and who are fraudulent to be got out. So instead of a ministerial committee, if you have a parliamentary committee, I feel, and you have strong parliamentary discussion before you bring out so many amendments. You see, every new judgment of a court should not lead to an amendment. So that is the only aspect I can say about a ministerial committee. I think it could be a parliamentary committee, which is, as the more it's discussed, the more people will come up with a reasonable, balanced view.
And the operative words being thinking well and discuss. So moving to the next question, that is by Samarth Sharma. He says, ma'am, if you could elaborate on the possible legal challenges to the PMLA amendment, since it dilutes major provisions of CrPC in order to assist ED, but at the same time, highly susceptible to misuse. I think there are more than one questions in this one question. The first part you have addressed, but I leave it to your discretion.
Yeah. So, see, the 45 I have discussed, the interpretation of section 2 I have discussed, the aspect of saying that they are two different procedures and nobody will treat them as one procedure, I have discussed. So what has happened is, as and when an amendment comes, uh, and sometimes the amendment, the as and when a judgment comes, sometimes the judgments are quite clear. For example, the judgment's very clear that there will be two separate cases by a special court, treated separately, not impinging on each other. There was no need for an amendment. So this, I feel, that, as I told you, that the two judgments which have discussed Nikesh Tarachand and discussed the amendment and said that judicial discipline, propriety makes them follow Nikesh Tarachand, and these amendments would not. And this is one of the most material amendments to my mind. Now, the 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 effect of making too many amendments waters them down. But the times in which we are living, where the courts are very conscious of economic offenses, and where I think it was perhaps in that Rahul Modi case, I'm not sure whether it was a relative of Nirav Modi or just another Modi, which was decided by the Supreme Court. The Supreme Court has talked a lot about economic offenses and talked about how economic offenses, which are very serious, amplitude, lots of money, public money, etc., etc. So the outlook of courts is also that public money should remain protected. So therefore, even though, according to me, these amendments were perhaps unnecessary and may not have been called for and could be possibly struck down on these grounds that each of them is trying to cover a judgment, or I think one of the amendments also about filing supplementary complaints or something. So it's basically trying every judgment or ratio that comes, it's trying to cover. I feel that's not very appropriate. But will they withstand or will they not is something which time will tell. Our judicial principles should be clear that a person should be presumed to be innocent unless shown to be guilty, that normally the burden of proof should not be on the accused. If it's on the accused, it remains as a proposition. If there is a probable defense, then the burden shifts back to the prosecution. That bail with 7 years cases, Arnesh Kumar, which is Supreme Court judgment, Gurbakh Singh Sibhya would apply, and that the twin conditions are bad. And that is a beautifully written judgment, as I said, worth every one of you reading it. So these are 3-4 of the basic principles. The last basic principle on adjudication, etc., is that third parties have to be protected. Third parties cannot be brought in net. A man may have spent his whole lifetime saving without realizing that that money is tainted money. So then you cannot be, he may have bought his only house from a person like that, or anything to that effect. So you have to consider, and that's what the law is. So that's how we want to see the interpretation growing also.
I see where you're coming from. Protection of the weakest rather than the strongest. Prosecution of the strongest. Geeta, you had mentioned that you have a meeting at 6. We have got 3 more still questions. Would you advise me to go on, or would you advise me to give a vote of thanks?
I think give a vote of thanks. If they can give me the questions, I'll answer them to the best of my ability.
I'll invite Shreya.
This was a 6 o'clock Zoom meeting with 4 or 5 people and a very old gentleman. So that's...
Yeah, I understand that, which is why I asked you.
Maybe so you can ask one last question, or maybe we can just wind up, whatever you say.
We'll wind up and we'll forward you the questions for your answers. So Shreya, if I can invite you for giving the vote of thanks.
Yes, ma'am. Hello, everyone. Good evening. As the co-convener of Society for Advancement of Criminal Justice, I take this opportunity to thank Geeta ma'am for joining us in these difficult times and sharing with us her valuable thoughts. Ma'am, we all present here are truly privileged to have interacted with you and learned the nuances of the topic, Prevention of Money Laundering Act. And we all have learned after interacting with you the nuances of this topic. Ma'am, we all are honored that you graced us with your presence and what has been a truly intriguing and informative session, especially the manner in which you dealt with the intricacies of the topic. Ma'am, I would also like to thank our Vice Chancellor, sir, all the faculty members at NUJS, and the faculty advisors of SACJ for helping us organize this session. I would also like to thank Vanita Patnaik, ma'am, for wonderfully moderating the session, and all the participants for posting such wonderful questions that helped us make the session great. I would also thank Ritu Malu ma'am for actively involving with us and helping us in organize this session from the chambers of Geeta ma'am. Thank you so much, everyone, and I hope that we all are taking with ourselves something from what has been a truly enlightening session. Thank you so much, everyone. Stay safe.
Thank you,
Thank
Geeta,
you.
from my side.
Thank you,
I'll
ma'am.
wait for you to come back.
Pleasure.
Thank you.
Pleasure.
Thank you. Take care.
Thank you.
Thank you, ma'am, on behalf of
Thank you,
Society for
ma'am.
Advancement of
Thank you,
Criminal
ma'am.
Justice.
I hope you enjoyed it. That's all.
Thank you. It was really because this topic is often less explored. Compare corporate laws with the criminal law nuances. So this was the first opportunity for us to deal with such a topic.
Okay.
Okay, great.
Okay.
Great.
That's good. That's good. Thank you, guys. Thank you so much. Thank you, Geeta. Bye.
Thank you.
Logging out.